Today we are discussing a powerful defense to tenants' non-payment of rent. This defense is something that most tenants have never heard of. Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I am Michelle Idkowitz. This is episode 50 of the Tenant Law Podcast. Big topic today. Today's case is a decision from June 2025 from the Appellate Term Second Department entitled Beverly Holdings New York LLC versus Blackwood. I'll put a link to this case in the show notes. As always, let's set the stage with some context. The New York City Department of Housing Preservation and Development, HPD has the ability to issue violations against residential premises in New York City of the New York City Housing Maintenance Code, which covers things like heat and hot water, mold, pests, gas leaks, fire safety, and a lot more. So it's a New York City agency enforcing the New York City Housing Maintenance Code, but state law also gives HPD some other tasks. The New York State Multiple Dwelling Law applies to buildings with 3 or more units, and Multiple Dwelling Law 302A tells New York City HPD to create a list of categories of HPD violations that it considers to be really, really bad. They're called Rent Impairing Violations. Rent impairing violations, that's the topic of today's episode. A rent impairing violation is a condition in a multiple dwelling which, in the opinion of HPD, constitutes, or if not promptly corrected, will constitute a fire hazard or a serious threat to the life, health, or safety of the occupants of the building. According to Multiple Dwelling Law 302A, if a rent impairing violation remains of record for more than 6 months and it's listed against your apartment or a common area of your building, then for any period beyond the 6 months, your landlord is actually prohibited from collecting the rent from you. I want to explain why this is a little different than some other things we've talked about on the podcast before. This rent impairing violation stuff, it's not what we call here on the Tenant Law Podcast a housing court hack. Of the 50 episodes we've had, 6 have covered different housing court hacks. That's what I call them. A housing court hack is a way to get a housing court case dismissed on a technical procedural ground. So a housing court hack gets your case dismissed, but it doesn't eliminate your underlying problem. A housing court hack doesn't mean that the rent is not owed or that the tenancy is not terminated. It merely buys you time while the landlord needs to go out and begin a whole other case on the same substantive ground. But if you need time to move or to get more money to pay the rent, then a housing court hack can be a very good thing. What we're talking about today is not a housing court hack. A successful defense based on rent impairing violations, that's a substantive defense. That means that you never have to pay that rent. So it's a big deal. But it's a hard statute to use. It's very, very tricky. There are a lot of exceptions. There are a lot of requirements. So I debated whether or not I should even share it with this audience, but I decided to. Here's how it works. So, Multiple Dwelling Law 302A, rent impairing violations. It applies in New York City, and it applies in any other city in New York State with a population of 400,000 people or more. You need to be in a multiple dwelling for this to work, which means a building with 3 or more units. What I'm saying here today, unfortunately, is not applicable to an apartment you rent in a 2-family house. We need to have an HPD violation. You can look them up very easily online by your address. But not all HPD violations qualify as this, only certain ones that are in this rent impairing category. So how do you know? When you look up your building on HPD and you see the list of violations, anyone with a little asterisk near it, if you've ever wondered what that asterisk is for, because for some reason the HPD website doesn't tell you, those are the rent impairing violations. But don't just go by the asterisk. There's a list. And I'm going to put a link in the show notes to the list. The list is published at the Rules of the City of New York, Title 25, which is the HPD rules, Subchapter Q, Section 25-191. I'll put a link in the show notes to the complete list of categories of HPD violations that are considered rent impairing. And now I'm going to give you a few examples. An example of a category of rent impairing violation that might show up in your individual apartment is category 742. Provide an adequate supply of gas to the fixtures. If something's up with your stove, you call the gas company and they red tag your stove and your stove is off, that might result in an HPD violation in the category of 742. Provide an adequate supply of gas to the fixtures. That is a rent impairing violation. Then we also have a category called 666, which is provide an adequate supply of heat. Let's talk about a couple of examples of rent impairing violations you might find in the common area of your building. Category 526, remove the illegal fastening at roof, bulkhead door, scuttle cover. I see this violation against so many buildings, 526s. I'm assuming that somebody decides they want the bulkhead door locked so tenants don't go on the roof, so they don't get hurt. And here's another common area rent impairing violation, a category 682, provide adequate lighting for public halls. If there are violations against your apartment or against the common area of the building you're living in that fall into these categories, if such a violation exists for more than 6 months, then we get into the rent impairing territory. If the landlord is suing you in a holdover, trying to get possession of your apartment and it has nothing to do with the rent, then nothing I'm saying here today helps you. This is a defense that you would use only in a non-payment proceeding when the landlord is suing you for rent. This rent impairing violation stuff, it is not a sword. It's only a shield, meaning this isn't a way that you can claw back rent from the landlord that you've paid. You see that there's a rent impairing violation against your apartment and it's been there for 2.5 years, but you're up to date on your rent. You've paid all your rent. You might want to say to your landlord, I didn't need to pay you for the last 2 years. Give me that rent back. I'm going to sue you for that rent. No, you can't do that. It says specifically in 302A, this is not a way that you can recover the rent that you've already paid. This is only a defense when the rent hasn't yet been paid. Okay, but there's more. You have to deposit the rent that you have been sued for with the court. It's technically with the Department of Finance. Now, I know this is where it's getting very weird because a lot of people would rightly say, hey, wait a minute. The whole reason I'm being sued for the rent is because I don't have the rent. If I had the rent, I would have paid it. I see I have a rent impairing violation. I see it's been there for more than 6 months, but if I don't have the money to deposit with the court, I guess I can't do this. It's odd. But I think I know what the legislature might have been thinking here, which is why this is an important moment in the episode for me to distinguish something very crucial, because I don't want my audience to make this mistake. Everything I'm saying here today is about this very specific thing called rent impairing violations pursuant to Multiple Dwelling Law 302A. Nothing I am saying here today has anything to do with the concept we've covered a lot here on the podcast, which is the warranty of habitability, which will get you a rent abatement. We're going to just spend a little detour for 2 seconds reminding you your rights pursuant to the warranty of habitability. So there's a warranty, an implied warranty of habitability in New York State. It applies to all residential housing. It does not matter if you don't have a lease. It doesn't matter if you have a lease and it doesn't say anything about the warranty of habitability. It doesn't even matter if you have a lease and the lease says, hey, no warranty of habitability for you. You can't waive it. Every residential tenancy in New York comes with an implied warranty of habitability, which means that there are certain standards that have to be maintained for your apartment. You can have a violation of the warranty of habitability without any HPD violation. The condition might just exist, but an HPD violation, even a non-rent impairing one, is prima facie evidence that the warranty of habitability is being violated. So what happens if a court finds you have a violation of the warranty of habitability? Well, you can get a rent abatement, even of rent that you've already paid. And that is within the discretion of the judge. So getting back to my example earlier, let's say you call the gas company and they come and they red tag your stove and your stove's off, and your stove's been off for 3 months. Well, that is technically a rent impairing violation, but you're not up to the 6-month mark yet. That doesn't mean that if your landlord takes you to court that you can't still use that. You can still say, hey, I have not been able to cook in my kitchen for 3 months. I can't make my kids breakfast. It's costing me a fortune to eat out, and I don't have my stove. I have no gas. A judge might say, oh, well, for those 3 months, I'm giving you a 50% rent abatement. I'm making that up. I don't know how much they would give you, but it's a pretty significant degradation of your warranty of habitability. So that's separate from what we're doing today. What we're doing today is this rent impairing violation stuff, which is more about the government decided they wanted these violations removed of record, because by removing them of record, it means that an inspector goes out and sees that the violation is truly cured, and they're trying to find ways to give pain points to landlords so that they will be incentivized to do that. So let's go back to where we were. In order to avail yourself of this defense, you have to deposit the rent that you've been sued for with the clerk of the court, which, like I said, is technically the Department of Finance. I want to say 2 things about that. Depositing money with the Department of Finance is a pain. There's a lot of paperwork. Getting it out is even harder. Let's say you deposit the money, assert the defense, and you win. And you're like, wow, I never have to pay that rent. That money is coming out of the escrow and it's coming to me. Well, it's not going to be liquid immediately. You have to get the court to write an order. You have to fill out forms. You have to wait for the government to mail you a check. And I believe you can check this, I believe it's a 2% fee also that they keep from the money. So all these things need also to be considered. The other thing I want to say is, once you put that money in the court, if the defense doesn't work for whatever reason, and we're not even done going down the list of things you have to do to make it work, then you're not getting that money back. That money is going to the landlord. So it's risky. So if you were to say, oh, look, rent impairing violation, I'm going to borrow that money from a relative. I'm going to take an expensive payday loan. I'm going to get cash on my high interest credit card so that I can make this defense work. It's a risk. If it doesn't work, you won't get it back. That needs to be considered. All right, more requirements for making it work. You have to plead your rent impairing violation defense. That means you need to put this in your answer. Right at the beginning of the case, you're going to put it in the answer that, oh, look, there's a violation. It's rent impairing. It's been there for more than 6 months. You have to express that early in the case in the written answer. If you don't, it's something called an affirmative defense, which means if you don't tell the other side about it early on in the case, you might be considered to have waived it and you can't use it. So you can't just spring this on the other side, on the landlord at trial. Then let's say we're at trial. You need to prove a couple of things. You need to prove that the violation really existed and is still there. Now, this is easier in some cases than others. If it's something ephemeral like heat, that's probably harder to prove, whereas a lock on a bulkhead door, you could just go upstairs and take a picture of it. You also need to prove that you didn't cause it and that you're not blocking the landlord from fixing it. You're not preventing the landlord access to fixing it. Now, one more thing, and this is where it almost starts to get a little strange. It's right there in Multiple Dwelling Law 302A that one of the things that the tenant needs to prove at trial is that HPD mailed notice of the violation to the landlord. That's a little weird because we don't work for HPD. How do I know what they mailed? How would I do this? Well, I'm going to put another case in the show notes. It's 170 New York Properties versus Edwards. It's a 2024 housing court case out of Queens, a very well-written decision. And the judge, and in this case, unfortunately, the judge could not honor the rent impairing violation defense because this element was not proven. And the judge suggests that a way it could have been proven is if they had subpoenaed HPD. That's our list of how you do this. It's long and it's, I want to say complicated, and maybe it is complicated, but it's more, this is a lot of legwork. This is a lot of work. Why don't we do this? Why don't we get into today's case and see how this plays out in the real world? Okay, getting into today's case, I'm going to kind of paraphrase. Sorry, you guys, the law is words. As I always tell you, the law is words. Your landlord is reading the words, so we are reading the words. Okay, this is in November 2019. It's a non-payment proceeding. The rent arrears that had allegedly accrued were from November 2018 to November 2019. So that's 13 months of rent. The tenant asserted an affirmative defense based on Multiple Dwelling Law 302A and deposited all the required rent into escrow. The rent impairing violation at issue in this case was was in a public hallway and was all the way back from April of 2016. And then there was another rent impairing violation on the roof from February 2018. By the time this tenant stopped paying rent in November 2018 and went into arrears, both these public area rent impairing violations had already existed for 6 months. By the time the tenant stopped paying rent, we were in rent impairing land. The tenant submitted the HPD violation report showing that the rent impairing violations were still not corrected. Again, that's a good way to show it. It's just that HPD came back out and re-inspected and did not lift the violation. But the landlord pushed back. The landlord said the tenant did not allow us access to correct the violations. But the lower court said, and the appellate court agreed that, but wait a minute, these rent impairing violations were in public areas, public hallway, on the roof. That wasn't an issue of access. Tenant wasn't blocking you from doing this because the tenant didn't have control over the roof or the hallway. As access was the only reason landlord gave for not correcting the rent impairing violations, the lower court had properly found that the tenant had established a Multiple Dwelling Law 302A affirmative defense, entitling that tenant to a 100% rent abatement. The tenant got off from having to pay for those 13 months, probably even more months beyond that as the case went on. And this brings up some really important tenant takeaways. But first, we're going to get the housekeeping out of the way. This is not legal advice. I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If this is legal advertising, it is terrible because I am asking you not to contact me. This pod is not a commercial for me or for my law firm. This is simply the podcast that I always wanted to make, 50 episodes of. So let us know what topics you would like to hear more about. Please subscribe and give us the highest rating. That really would help this information get to more people. It is time for the tenant takeaway. Tenant takeaway time. The rent impairing violation defense is powerful because it's substantive. It means the rent will never be owed. And this could result in months or years of arrears not being collectible. Also, the law potentially has a strong social purpose to get the housing stock of New York City to a place where every building is free, in reality and on the record, of the most pernicious and dangerous violations. I have to tell you, 1 out of every 2 buildings I look at in my practice as a litigator or a consultant has rent impairing violations associated with it. So there's plenty of this out there. But because you must deposit the rent in contention in order to utilize the defense, and because if something goes sideways, and as we saw today, a lot can, that money you deposit could end up being released to the landlord if it doesn't work out. So utilizing the rent impairing violation defense, it can be very risky. It's also a lot of extra work. And this is why, in a perfect world, I would suggest that you only utilize this defense with the help of a lawyer who knows what they're doing. And that's why I almost didn't even want to drop this episode. After 50 episodes, it should be clear who my intended audience is, although all are welcome here. My audience is New York City's middle-class residential tenants who make too much money to qualify for a free attorney, but who do not have enough money to afford a well-qualified in landlord-tenant law attorney. And that cohort is most people. That's New York City's middle class. And that's not changing anytime soon. So if most New Yorkers are going to be unrepresented or represented by lawyers who don't have a lot of experience in landlord-tenant law, then how am I helping people by holding this information back just because it's complicated and not without controversy? That's why no one else covers this, because there's no quick, easy way to present this material on rent impairing violations. I've been thinking for years about how to use all this esoteric landlord-tenant law knowledge rattling around my brain to help many people. With the podcast, I think I may be on to something. I'm up to 50 episodes and I'm approaching 6,500 downloads, and I've done nothing to promote this thing. I haven't spent one dime on advertising. I'm not doing any social media. I've just published. That's all I do. And I'm technically doing everything wrong. I don't have guests to cross-promote to their audiences. I'm not doing a video component. I'm not even publishing on a regular, consistent schedule. I can go 6 weeks and I come back and here you are. And the numbers are increasing all the time. I'm not even totally sure who you are, but I'm starting to get a better sense because more people are reaching out. I was contacted by a very nice listener recently who said they're a non-lawyer housing advocate and they find the podcast helpful in their work. That's very exciting to me. The podcast will always be designed to go directly to tenants, but if it can help people who work in housing help their constituencies better, that may be a good way to multiply the effect of this content. I'm also aware that some lawyers are listening. I'm honored that you're here, that a couple of you have reached out. Just know that the way that I would teach lawyers in an accredited continuing legal education course would be very different than what I'm doing here, going directly to the public. It's not lawyer training, but if this points you in the right direction and gets you started, I'm happy about that. I've managed to go 50 episodes without talking about politics, and that's hard. That's a hard thing to do when your topic is housing law, and I'm not talking politics now. I'm going to spend a paragraph telling you how I see things, and I think it's relevant to our topic and our takeaways. So my friends on the right say that New York City tenants have way too many rights. And I tell them, you're just not seeing what I'm seeing. New York City tenants don't really have so many rights because they don't know they have rights. And not knowing that you have rights is it's the exact same thing as not having them at all. And when tenants do discover that they have rights, they also discover that it's expensive and risky to enforce many of them. I could give you 20 more examples like this rent impairing violation thing. But then my friends on the left say, oh, well, we need more tenant-friendly laws. And I'm like, really? How is that helping if people already have more rights than they do anywhere else? and they don't know about them. And if they do know about them, the burden is on the tenant to enforce the law. Maybe we need less new laws, which, by the way, always makes things more complicated for a long period of time. And maybe we need more basic enforcement by the government of the laws it already put in place. Or if you're going to change something, change the enforcement mechanism so it's not always foisted on the tenants. And this rent impairing violation thing is the perfect example. Clearly, the government wants to eliminate these types of dangerous conditions. That's why they made the law. Mr. Landlord, if you don't eliminate the condition, you will feel pain. That's how laws work. But why is the penalty that the tenant can withhold rent? Let's just think about that for a minute. Just think about how this works. That means that the tenant has to withhold rent and get sued. And who wants to be sued? It's time-consuming, it's expensive, it's embarrassing. It can affect jobs, dating, whatever. So you have to be sued, and then you have to successfully mount this complicated defense in order for the landlord to truly finally feel the pain of being deprived of the rent. Why is it that way? Why not just say, okay, Mr. Landlord, you have a rent impairing violation. The fine is going to be $5,000 every day that rent impairing violation is in place. And by the way, we're going to alert your mortgage lender. That'll do it. Those locks will fly off those bulkhead doors real fast if that was the rule. But they're not going to do that. The reason this isn't me talking about politics and ranting is I'm trying to do something about it. And wait for it. I'm doing podcasting. My answer is education. So I just did 50 episodes that took deep dives on topics that, for all but a few of them, you can't even find anywhere else. I'm going to give you an example of an episode that I'm particularly proud of, although it's not my most popular episode. Episode 34 is on vacate orders. So let's say the person in the apartment below you, God forbid, starts a fire, and your unit is badly damaged, and the city posts the vacate order. You can't go back to your apartment. What are your rights? What are your rights with respect to the landlord? There are a couple of places on the internet where you can look that give you a little information, but nothing covers it as holistically as I do in episode 34. And I get a call at least once a month from somebody in that position. So instead of saying the same thing over and over or cutting and pasting the same email over and over, I can just refer them to episode 34. Education is really the only answer, because education, think about this for a minute, it takes these laws that are already in place and it makes them actually useful to people looking for solutions. And again, let's say you start down the road of asserting the rent impairing violation defense. Remember, you have to raise it in your answer. So you raise it in the answer, you point to it, you point to the statute. Now the landlord and the landlord lawyer realize how powerful that is. And if that violation is in the common area, now they know that you just might tell everyone in the building that nobody needs to pay next month's rent. That could lead to, again, the leverage that you need, perhaps not to win the whole case, but to negotiate a better deal for your family of what you want and need. More time, waived rent, a renewal, or maybe, you know what? Or maybe you do tell everybody because you're very socially minded and maybe you have a big rent strike. I'm not telling you what to do. I'm giving you options. And it all starts with you being aware of what your rights are. And there you have it. The law belongs to you, New York City. But your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.